She didn't ask. She didn't knock. She didn't leave a note. She just showed up with a can of beige paint and painted my private fence. No warning, no notice, no permission. Just Karen Whitfield, HOA President, a roller, and the belief that her authority had no limits. She was wrong about that. I read every line of the CC&Rs. I hired a contractor. I drafted the demand letter. I walked it across the street on a Saturday morning and handed it to her face. She called a meeting. She sent her brother-in-law. She fined me for the color she painted. So I took her to small claims court, and 11 minutes later, it was over. This is the story of the fence, the folder, and the woman who learned that knowing the rules is the ultimate power. I am the kind of person who notices small things. The way a door sits slightly off its frame. The way a neighbor's car is parked 2 inches closer to the curb than usual. The way light changes in the early morning before anyone else is awake. I notice these things because I pay attention. I've always believed paying attention is one of the most useful habits a person can have. It was a Tuesday. I know because Tuesdays are the days I take my coffee on the back porch before the world starts up. I like that time. The street is quiet. The birds are doing their thing. The day hasn't asked anything of me yet. I take my mug, the big blue one my daughter painted for me at one of those pottery places, and I sit in the old green chair and just exist for about 20 minutes before I have to be a person again. That particular Tuesday, I settled into the chair, took my first sip, looked out past the garden toward the back fence, and stopped. My fence was beige, not faded, not weather-worn, not subtly changed by the sun over time. Beige. Freshly painted, flat, uniform beige. The color of a government form. The color of waiting rooms. The color of every other fence on Morningwood Drive since Karen Whitfield had decided, during her 3rd term as HOA president, that the neighborhood needed to look like one continuous, soul-crushing canvas of sameness. I put down the mug, walked across the wet grass in my socks, pressed my finger to the wood. The paint was tacky, still curing. Whoever had done this had been here within the last 12 to 18 hours. They had been inside my property line, past my gate, into my yard, with brushes and rollers and a can of HOA-approved beige paint, and they had covered my fence without ringing my doorbell, without leaving a note, without one single word to me. I stood there for a while. The birds kept going. The coffee was getting cold on the porch behind me. I already knew who it was. There was only one person on this street who moved through the neighborhood like she had a deed to the whole thing. One person who had once slipped a printed note under my door because she felt my porch light was too warm in tone for the community aesthetic. One person who had measured my recycling bin with an actual tape measure. Karen Whitfield, HOA President, keeper of the beige. I went back inside. I did not go to Karen's door. Not yet. I had learned the hard way over many years of dealing with difficult people that you never make your first move when you're angry. Anger makes you sloppy. Sloppiness makes you lose. I had no intention of losing. To understand what happened, you need to understand Karen. Karen Whitfield had lived on a Morningwood Drive for 11 years. 3 years longer than me. In Karen's world, those 3 years translated into a kind of seniority that wasn't official anywhere but lived very vividly in her mind. She talked about the neighborhood the way some people talk about a business they founded, with ownership. With the particular pride of someone who believes the place would fall apart without them. She had been HOA president for 6 consecutive terms, not because the neighbors loved her. They didn't, not really, not most of them. She had the job because nobody else wanted it badly enough to fight her for it. Running for HOA president means attending meetings, writing minutes, chasing dues, and sending violation notices to your neighbors. Most people would rather watch paint dry, which is ironic given what Karen had done to my fence. The previous HOA president, a retired teacher named Doan, had held the job for 2 terms and then quietly listed his house without telling anyone, moved to Arizona, and did not leave a forwarding address. The one before him, a woman named Patricia, had simply stopped showing up to meetings until Karen declared the position vacant and called a special election she herself won. I had heard both stories from Marcus, my neighbor 3 doors down, who had lived here longer than anyone and remembered everything. Karen has driven out 2 presidents and 1 entire family, Marcus told me once, over the fence, my mahogany fence, before it became a casualty. The Hendersons. You remember them? The ones with the yellow lab? I did not remember them because they had left before I arrived. Gone, Marcus said. Holiday lights dispute. Karen sent them 17 notices. I had tried, in my first weeks on the street, to be neighborly. I showed up at Karen's door with a bottle of red wine when I moved in. She accepted it graciously and then, as I was turning to leave, said, "Will that sofa be visible from the sidewalk? We have standards around visible clutter." I laughed because I was sure she was being dry and funny. She was not being dry and funny. Over the years, Karen and I had reached what I can only describe as a cold détente. I followed the rules I had agreed to when I signed my deed. She found other things to flag: the recycling bin, a basketball hoop that belonged to the previous owners and that I had not technically installed, a wind chime my mother gave me that Karen described in an official notice as an auditory imposition on neighbors. I took down the wind chime. My mother was not pleased, but painting the fence was different. Every other thing Karen had done involved paper, notices, fines, letters. Paper is annoying, but paper stays on your side of the property line. What Karen had done this time was physical. She had come into my yard, my private property, and changed something that belonged to me without asking. That was a different category of action entirely, and I intended to treat it that way. I spent most of that Tuesday at my kitchen table with a cup of fresh coffee, my laptop, and the HOA's governing documents, which I had downloaded from the HOA portal and never once opened since the day I bought the house. I want to be honest, reading HOA documents is among the least enjoyable activities available to a human being. They are written in a style that seems deliberately designed to make you stop reading. Long sentences, subclauses, inside subclauses, references to appendices that reference other appendices. I have read instruction manuals for industrial equipment that were more engaging, but I read every word that day because I needed to know exactly where I stood. The CC&Rs, covenants, conditions, and restrictions were 43 pages long, plus 6 appendices. I started at page 1 and did not stop. Section 7.3 dealt with exterior appearance standards. This was Karen's favorite section. It stated that all fences visible from common areas or adjacent public streets must conform to the approved HOA color palette, which was listed in Appendix D, 3 shades of beige, 2 shades of taupe, and 1 shade described as warm sand, which appeared identical to the other 5. My fence ran along the back of my property, bordering the rear service alley. It was not visible from any street. The alley was a narrow strip of pavement used, mainly by trash trucks and the occasional delivery driver. I checked the definition of common areas in Appendix B. The rear alley was not listed. It had never been listed. The fence, technically, did not fall under Section 7.3 at all. But even if it had, even if Section 7.3 applied, there was still the matter of Section 12.1. Section 12.1 covered enforcement procedures. It was very specific. Before any enforcement action could be taken, the HOA was required to a. Provide the homeowner with written notice of the alleged violation, b. Allow a minimum of 30 days for the homeowner to correct the issue, and c. Only then, if uncorrected, pursue the listed remedies. The listed remedies were fines and, in extreme cases, legal action through the courts. There was nothing in Section 12.1 about entering the property. Nothing about making alterations. Nothing about picking up a paintbrush. I kept going. Section 14.4, Trespass and Property Rights. I read it twice to make sure I understood it correctly. It stated, "Nothing in these covenants shall be construed to grant the HOA or its representatives the right to enter upon private property without the express written consent of the homeowner, except in cases of emergency, as defined in Section 14.5. I flipped to Section 14.5. The emergencies listed were fire, flooding, and structural collapse posing risk to adjacent properties. A fence being the wrong color was not a fire. It was not a flood. No one's structure was collapsing. Karen had not sent a notice. She had not given me 30 days. She had not obtained written consent. She had not called an emergency. She had simply decided, on her own authority, that my fence needed to be beige, and she had made it beige. I made a folder on my desktop labeled fence. I screenshot every relevant section of the CC&Rs. I printed them and used a yellow highlighter on the parts. That mattered. Then I called Marcus. "She painted your fence." He said it flatly, the way you repeat something you need a moment to absorb. "She painted my fence." A long pause. "Man," he said. "She finally went too far." "That's what I thought," I said. "What are you going to do?" "I'm going to charge her for it," I said. The first thing I did was establish exactly what it would cost to restore the fence. The original stain I had used was Cabot Australian timber oil in Jarrah Brown, a specific product. I had chosen carefully because it brought out the warm reddish tones in the cedar wood and also because it protected against moisture without making the grain look plasticky. I had applied 2 coats myself over a weekend 3 summers ago. My back had ached for days afterward, and I had been unreasonably proud of the result. I contacted 3 painting contractors and explained the situation. I sent each of them photos of the fence, before and after, and asked for quotes to strip the beige and restore it to the original color. The quotes came back at $480, $575, and $710. The cheapest contractor couldn't come out for 6 weeks. The most expensive had included a complexity surcharge that he could not fully explain when I asked. The middle, quote, $575, was from a man named Dale who came to the property in person, looked at the fence, ran his hand along the wood, and shook his head slowly. "Someone did this on purpose?" he asked. "Someone did this as a community service," I told him. Dale looked at me. "You want the original color back exactly?" "Exactly," I said. He nodded. "Give me a week." I booked Dale and got a written quote on company letterhead that went into the folder. Next, I gathered my evidence of the original fence color. I had photos from a barbecue I'd hosted 3 summers ago, timestamp intact, taken the same weekend I'd finished staining. Because I had been so pleased with how it looked that I photographed it like a proud parent. I had the original receipt from the hardware store showing the exact product and color code. I had a text message I'd sent my sister with a photo attached, captioned "Finally done with the fence," which she had responded to with a thumbs up and absolutely no further comment, because my sister has never once pretended to care about fences. I printed all of it. Then I drafted the demand letter. I wrote 3 versions. The first version was honest but unusable. It contained the phrase, "I cannot believe you had the nerve 4 times, and are you serious right now?" twice. I deleted it. The second version was so careful and diplomatic that it barely sounded like I was upset at all. I deleted that too. The third version was right. It stated the facts clearly and without emotion, on or around the date in question. Ms. Whitfield had entered my property without consent and applied paint to my cedar fence, altering it from its original color. This action violated Section 14.4 of the CC&Rs and constituted trespass and unauthorized modification of private property under state law. Restoration of the fence to its original condition would cost $575 per the attached contractor quote. I was requesting payment of this amount within 30 days. If payment or restoration was not received by that date, I would pursue the matter in small claims court. I signed it in blue ink, photographed it, sealed it in an envelope. And on a Saturday morning when I knew Karen would be home, because Karen was always home on Saturday mornings, running HOA business from her kitchen like a small government, I walked across the street and knocked. She came to the door in a cardigan. She smiled at first, the way she smiles when she's about to tell you something she's already decided. "This is a formal demand letter," I said, and I held out the envelope. She looked at it, then at me. "Excuse me? Everything is explained inside," I said, and I turned around and walked home, and I did not look back, because I have learned that not looking back is important. Karen did not write a check. I had not expected her to. Karen was not the kind of person who receives a demand letter and quietly folds. Karen was the kind of person who receives a demand letter and calls a meeting. Within 48 hours of my delivering the envelope, 3 things arrived in my mailbox. The first was a formal HOA violation notice. It cited Section 7.3 of the CC&Rs and stated that my fence was currently in violation of community color standards. The fine was $150, payable within 30 days. The fence in violation was beige, the color Karen herself had painted it. She was fining me for her own paint. The second item was a personal letter from Karen, written in a tight, controlled script on HOA letterhead. It stated that she had acted in good faith and in her capacity as Community Standards Officer to address a long-standing aesthetic violation and that she believed her actions were both appropriate and necessary. She expressed hope that I would reconsider this adversarial approach in the spirit of community harmony. The third item was a printout of a section of the HOA bylaws, not the CC&Rs, but the bylaws, which govern how the HOA operates internally. The word President was underlined in red pen 3 separate times on the page. I stared at this for a while. I was not entirely sure what point she was making. I put it in the folder anyway. Then Marcus texted me, "Did you get the meeting notice?" I had not gotten a meeting notice. Karen had sent it by email, and I had apparently been removed from the HOA email list at some point, something I noted carefully and added to the folder. Marcus forwarded it. Emergency Special Session of the HOA Board. Agenda. 1 item. Fence known compliance -14 Morningwood Drive. That was my address. I showed up. Karen's living room was arranged with 11 folding chairs in a semicircle. 7 of the 11 were occupied when I arrived, which caused an immediate and visible shift in Karen's expression. She had not expected me. She covered it quickly, smiled, said she was glad I could attend, and went to stand at the front of the room where she had set up a small easel with printed materials. She had a laser pointer. Her living room is approximately 200 square feet. There was no earthly reason for a laser pointer. She walked the room through the history of my fence. She showed a photograph of it, the mahogany one, and described it as a persistent and documented violation of community color standards going back multiple years. She pointed the laser at the photo. She then showed a graph with a downward line that she said illustrated the impact of non-compliant properties on neighborhood property values. She did not explain where the graph came from or how it had been generated. The line went down. That was the point of the graph. When she finished, I raised my hand. The fence in those photographs, I said, was painted by me on my property, using products I chose and paid for. The fence as it currently exists, the beige one, was painted by Ms. Whitfield without my consent, without notice, and without any authority granted to her by the CC&Rs or any other governing document. I have a formal demand outstanding for $575 in restoration costs. I would also like to note that I am recording this meeting. I held up my phone. The room went quiet. Someone in the back row coughed. Karen said the meeting was adjourned, effective immediately, and that further discussion would take place in writing. She said this in the voice she uses when she's holding herself very still, so that she does not say something she will have to walk back later. I recognized the voice because I had heard it before, during the wind chime dispute. I walked home. Marcus texted me a single thumbs-up emoji before I even got through my front door. 30 days passed, no check arrived. The fence remained beige and waited. On day 22, I received a letter from someone Karen described as HOA legal counsel. The letter was one paragraph long and stated that the HOA disputed liability in this matter and reserved all rights. It was signed by a man named Robert Whitfield, who I later confirmed, through a 15-second internet search, was Karen's brother-in-law, who worked in residential real estate and was not, to my knowledge, a litigator. The letter was typed on plain paper with no law firm letterhead. I added it to the folder, which was now quite thick. On day 31, I went online and filed a small claims court complaint against Karen Whitfield, individually, not the HOA. Karen personally. This was an intentional choice. The act of painting the fence had been Karen's act. She had shown up with the paint. She had held the brush. Whatever authority she believed she had, the physical action was hers. If the HOA wanted to argue that she had acted as their agent and that they were therefore responsible, that was an argument they could make in court, but I was naming the person who had touched my property. The filing fee was $75. I listed it as part of my damages. I submitted photos of the original fence with timestamps, the hardware store receipt, the contractor quote on Dale's letterhead, the relevant CC&R sections with my highlighted annotations, the demand letter with its delivery date, and a brief written statement of events in plain language. The court scheduled a hearing for a Thursday morning. 6 weeks later, I wore a clean button-down shirt, the one I wear to job interviews, and the occasional funeral. I arrived 15 minutes early and sat in the hallway outside the courtroom, going through my folder one more time. I had organized it with numbered tabs. Tab 1, Original Fence Photos. Tab 2, Receipts. Tab 3, Contractor Quote. Tab 4, CC&R Sections. Tab 5, Demand Letter. Tab 6, Karen's Response Letters. Tab 7, the HOA violation notice she'd sent me for the beige fence she had painted. Karen arrived 8 minutes before the hearing with her brother-in-law, who was carrying a briefcase and wearing a suit. He nodded at me in the hallway with the careful blankness of a man who has been briefed on the situation and is trying to project confidence about it. The judge was a woman in her 60s, with short gray hair and reading glasses on a beaded chain. She had the manner of someone who has heard every version of every dispute and has developed a highly calibrated sense for which ones are straightforward and which ones are going to require patience. She read both parties' submitted materials before she said a word to either of us. Then she looked up. "Ms. Whitfield," she said, "did you paint the plaintiff's fence?" Karen drew herself up and said that she had acted in her capacity as HOA President to address a documented community standards violation. She said that the fence had been out of compliance for years. She said that she had exhausted other options. She said the word community 7 times in approximately 90 seconds. The judge picked up the CC&Rs. She had a copy, I had submitted one, and Karen had submitted one. She turned to section 14.4. She read it, then she looked at Karen. "Where in this document does it authorize you to enter private property and paint someone's fence?" Karen's brother-in-law leaned forward and began to say something about the spirit of the governing documents and the HOA's broad mandate to maintain community standards. The judge held up one finger, just one. He stopped. I'm asking Miss Whitfield. Karen said that the spirit of the covenants. I'm not asking about the spirit, the judge said. I'm asking about the text. Show me where it says you can do this. There was a silence that lasted long enough to be uncomfortable for everyone in the room except me. The ruling took 11 minutes to deliver. Karen was ordered to pay $575 for fence restoration and $75 for court costs. The judge stated, clearly, and for the record, that no provision of the HOA governing documents authorized the defendant to enter private property and make physical alterations without the homeowner's consent. She used the word trespass. She also noted that the HOA's violation notice, the one fining me for the beige color that Karen herself had applied, raises serious questions about the good faith of the enforcement process. I thanked the judge. I gathered my folder. I did not look at Karen on my way out. In the hallway, Marcus, who had taken a half-day off work to attend, clapped me on the shoulder. 11 minutes, he said. A record. Dale came on a Friday. He arrived at 7:30 in the morning with his truck, his equipment, and 2 helpers, a young man who worked in careful silence and a woman named Grace, who sang quietly to herself while she worked and did not appear to notice that she was doing it. They stripped the beige first. It came off in long, curling flakes, the color of old envelopes, falling into the drop cloth Dale had laid along the base of the fence. Watching it come off was satisfying in a way that I recognized was probably disproportionate to the situation, but that I chose not to examine too closely. Then they applied the Cavett Australian timber oil in Jarrah Brown. 2 coats, same as I had done originally. The mahogany color came back slowly at first, and then all at once, the cedar grain visible underneath, warm and reddish-brown in the morning light. By early afternoon, it was done. Dale stood beside me and looked at it. "That's a good fence," he said. "It is," I agreed. "People shouldn't paint other people's fences," he said. "No," I said. "They shouldn't." He nodded once, the way craftsmen nod when a job is right, and then he and his team packed up and left. I stood there on my own for a while, with a cup of coffee, looking at the fence. The birds were going. The sun was warm. The mahogany was exactly as I remembered it. Karen's check arrived on day 28 of the court's payment window. It came in a plain white envelope, sealed with a strip of tape, with no note or letter inside, just the check, filled out in the exact amount required, $650. I held it for a moment. Then I endorsed it, drove to the bank, deposited it, and transferred the full $575 to Dale that same afternoon. The remaining $75 covered the court filing fee. I was financially whole. The HOA in the months that followed went noticeably quiet. The violation notice Karen had sent me for my beige fence, the fence she had painted, was never officially withdrawn. It simply vanished from the HOA portal one day without explanation. No one sent me a letter about it. I did not ask. I attended the next annual HOA meeting. I had not attended one in 6 years, and my presence clearly registered with Karen, who straightened slightly when I walked in and chose a seat in the 3rd row. She ran the meeting efficiently. She still had the laser pointer, but she paused before each item to check something on the printed pages in front of her, which I recognized after a moment as the CC&Rs. She was checking the rules before she spoke. That was new. Afterward, Marcus caught up with me in the parking area beside his car. The evening was cool and the street lights were just coming on. "She's gonna come at you again," he said. "You know that, right? People like Karen don't let things go. She's going to find something, a crack in your driveway, a shrub that's 2 inches tall, something." "I know," I said. "So what are you going to do?" "Keep attending meetings," I said. "Keep reading the documents. Keep the folder." He thought about that. "You still have the folder?" "I've updated it," I said, added the court ruling. Added tonight's meeting notes. Added the fact that the violation notice disappeared from the portal on a specific date, which I documented with a screenshot. Marcus looked at me for a moment. "You know," he said, "you might be the only person on this street who actually enjoys this." I thought about that. Maybe he was right. I don't think I enjoy conflict, exactly. But I do enjoy being prepared. I enjoy knowing the rules better than the person who's trying to use them against you. I enjoy the particular satisfaction of a well-organized folder. I walked home in the dark. My fence was mahogany. The nights were getting longer and cooler, the way they do in fall, and the cedar smelled faintly of the oil, warm and deep and right. I sat on the back porch with the last of my coffee, a Tuesday habit that had expanded to Fridays, and now, apparently, to the evenings after HOA meetings as well. The neighborhood was quiet. The fence stood where it had always stood. It was the right color. It had always been the right color. And if anyone came near it with a paintbrush again, I had a folder, a judge's ruling, and absolutely nothing better to do.